Welcome back to Hope at Dawn right here at Hope TV. This is where you look and live. Being a Monday, it's all about legal matters, and this morning, no exception. And we are joined on set by an advocate of the High Court. His name is Advocate Oscar, and he will be telling us a thing or two about law logs and especially matters to do with labor laws. So allow me to welcome on set our guest. Good morning, Oscar. And it's a pleasure to have you this morning, looking at this very interesting and very important topic, labor laws, and especially touching on employment. But first of all, a brief introduction of yourself.
Yes, my name is Oscar Onyango. I'm an advocate of the High Court and also a partner at Oscar and Associate Advocates. At Oscar and Associate Advocates, we specialize in employment and labor laws. We assist both employees and employers in ensuring that the risks that are associated with those laws, flaunting those laws, are minimized at all levels.
Yeah.
Yes.
Yeah. You mentioned that. I was about to ask, then I said no. Do employers have rights? But then
They do.
but they do have rights as well.
Yeah, the Constitution
that's
is
a conversation we will have one of these fine days. Looking at the employers' rights. Yeah.
Good. And I think even for those who are watching, maybe they're wondering, what are labor laws? Where does it stem from? Just tell us a bit of a background information on labor laws and, the rights of employees. Where does it stem from?
Well, labor laws are essentially, they were essentially developed to protect employees because there's the understanding that there's an imbalance of power between the employer and the employee. So there's a risk of exploitation. So these laws came into play so that they bring a framework within which employers and employees can relate. Yeah, so primarily in Kenya, we have the Constitution under Article 41, which talks about fair labor practices, and one that you should not discriminate against an employee. You should have a good working environment, and many others under that article. We have the Employment Act. It's the primary act that guides now the relationship between employers and employees. We have the Labor Institutions Act. We have the Employment and Labor Relations Act. That one now establishes the employment court. We have the Labor and Labor Relations Court. So it's a court that is similar to the High Court. So that act establishes it. So that, in a nutshell, gives us a framework of what we have in Kenya in terms of labor laws.
Yes. And Oscar, what's and why is it important? And here it's for both employer and employee to know about the labor laws that are there in the nation.
Well, if we may start with the employers, there's a lot of risk. An example is the number of cases that are being filed in court today, because people have become aware of their rights. So if you flout these laws, then you're putting your organization or business at risk. So it is important that employers understand what is expected of them when they're drawing the employment contracts, what needs to go into the employment contract, and what they need to avoid so that they do not fall under the risk of multiple suits. Because I'm very sure not every organization would handle 100 suits that they are not planned for at the beginning of maybe the year. They have their financials and all that. So if people are going to institute claims against you, and you have to part with substantial amount of what you had not planned for, then that's in itself a risk. When we come to employees, it's important that they understand their rights because you are offering a service. That service needs to be paid for. And it's your source of livelihood. So if you do not know your rights, there is situations where you would be terminated, you do not know where to go to, you do not know what actions to take and all that. So you find some employees just leaving after they've been unfairly terminated. But those who are aware of their rights would inquire, or in the very least, they would inquire. But those who understand the process of the court can lodge claims. Yes.
All right, that's good. And there's something that you sent, which was basically a case study. And, we're just saying how amazing and very good it is. The fact that we get to have such a story, even coming at such a time as this when we are having this conversation on labor laws. And this story says that NGO ex-staffer awarded 3 million shillings for unfair sacking. This is a story that you have a lot to say about, I would say, because you are the lawyer who was, is it on the complainant side?
Yeah, I was the one
Yeah.
representing the claimant. We call them claimant.
Okay.
Yes.
These terms, I'm still learning.
Legal jargons.
The legal jargons.
Yeah.
And you got to actually win this case. Now, just take us through, because you've talked about that employees need to know their rights. They need to know their rights very well. And, this is just a story that shows us the advantage of someone knowing their rights, because now they were compensated 3 million shillings for unfair sacking. Just tell us a bit about that.
Well, first of all, I would have to state that there's that confidentiality between you and my client.
Yeah.
Yeah, but just to give you an overview of the case, this is a claim of this particular client had been terminated on grounds of the fact that our contract was coming to an end. Usually we have some type of employment called fixed term contracts. A fixed term contract, ordinarily you are not expected it's not expected that it would be renewed at the end of it. There's no obligation on the employer to renew it. So that is the situation we were facing. Besides the fact that she was terminated when she was due for maternity. Yeah, so when we went to court, court had to consider those issues. But one thing that stands out, the fact that the employer has no duty to renew such contracts, the other factors that could be considered by court. So for instance, if an employee has worked in an environment for many years, although under short contracts that are being renewed annually or in 2 years, like that one, the court would take that one into account if the employee has no disciplinary issues, and if there is no pressing issue from the side of the employer to terminate that contract or not to renew. Because there are other issues that might arise, especially in organizations such as NGOs, when there's donor funding, when there's a drop in the donor funding, that would be a legitimate reason not to renew. But if that is not provided, you've not given out that, then the court would not find in favor of an employer who fails to renew. Yeah.
It's an interesting one because, and especially the recent past, we have had organizations laying off people on many grounds. You see ads, you see notices. The media industry as well. We have not been left behind. We have become also victims and of redundancy. So where does that fall in as far as the labor laws in the country are concerned, redundancy, and what are the legal steps so that as an employee, in case I see that the law was not followed, I can be able to pursue the matter to the end?
Well, redundancy is what they may call layoff, as you've said.
Yes.
In Kenya, employees are protected. There are procedures to be followed for an employer who is considering redundancies. Under the Employment Act, we have Section 40 that provides for those steps. Number one, the employer needs to inform the employee of an impending redundancy in time. So that is what we call notice. It could be 1 month or 2 months, depending on what the employment contract provides. Besides that notice, an employer is also required to provide notice to the labor office of the area within which an employee is working. So if it's in Nairobi, you have to go to a labor office within Nairobi and give notice that you're considering terminating employees of this number as of this time.
Yeah.
So besides the notices, you are also required to provide criteria that you've used in identifying employees that you are releasing. So you're not just going to wake up one day and say, so and so we are releasing you. So there's a procedure. The court has always employed the formula called last in, first out, such that an employee who has stayed for long would not be considered for redundancy ahead of one who has just come recently. Yes. So that would be considered. So if you just wake up as an employer and you're terminating an employee that you've had for a longer period, and leaving the one that you've just employed recently, then you have to justify. Yeah, but besides having worked for a long period, you also have to you have to show that this position was critical to the organization. Yeah, because you could have worked here, but as a janitor, was a position that did not require. Yes, so that has to be put into consideration. Another thing is that that position has to disappear. So you're not going to camouflage redundancies under some guys that now you're releasing this individual, but that position remains. That position has to disappear. That is what we call abolition position.
Okay.
Yeah, so it has to disappear. So those issues taken together, then now the court would consider that redundancy as proper. But if one procedure is not followed, then it would, the procedure, the whole exercise would fail.
Yeah.
Yes, and then now you expose yourself as an employer to multiple suits. Yes, and again, redundancy are very expensive to employers, because considering the number of years that an individual has worked, could have worked for 15 years, you're paid 15 days for each complete year. That is the severance pay. Besides the claim for unfair termination, which is 12 months of your salary. Yes, so that one would really put an employer at risk. That is why most of the time they take care not to flaunt those procedures. Yes.
And okay, and does it mean maybe when it comes to the laying off, is there a law that can tell you when? Because sometimes there are people who are just laid off Ivoto, and they just leave Ivoto immediately. Like, you come to work and you're told you cannot work anymore. So is there any laws that govern the time that you need to give someone before now they leave? Is there payment that needs to be made, especially if they knew contract will require 1 year or more? Like, how does that work?
Well, employers are required to give notice. Notice is essential to prepare an employee that will be releasing at this particular time. In the absence of notice, an employer is required to pay in lieu of that notice. Then again, in terms of payments that are available, it depends on the contract that you have. Because there are organizations that may have in their contract that there's some money that is supposed to be paid when you're leaving at a particular time. So it all depends on the terms of your engagement. Yeah, but when it comes to notice, that is a mandatory requirement that an employer has to give. So it's one of the claims you can also claim. Besides unfair termination, you'll also be asking for notice pay. Yeah.
All right. And the other thing that is also contained in labor laws, the country's labor laws, I believe, is belonging to a union. But you find that there are organizations that really do not encourage their members to belong to a union. So how do they go about that?
A right, every employee is entitled, as a right actually, to belong to a union. That is under Article 41 of the Constitution on Fair Labor Practices. So one of the issues under that article is that an employee is entitled, as a right, to join a union and to picket and even to go on strike. Yes, as long as it is
in the law.
It is in the law.
Yeah.
So you would not be victimized that you participated in a lawful strike. Yes, because strike is just essentially to put pressure on the employer to act on a particular need. Yes. Yeah, so.
Okay. And then now talking about sick leave, because we also have that most of the time. And there are situations whereby someone has taken a sick leave, but then when you've been given a particular period of time, but when you get back, you're still not in a position to continue maybe working the 8 hours, coming to work every day. Is it possible to combine, the sick leave and the annual leave days, or how does that work?
The law provides for sick leave. I think it's under must be section 30 of the Employment Act. You are entitled to sick leave, 7 days paid, and then now with an additional 7 days on half pay. That is what the law provides. But since we work in an environment where we are dealing with human beings, organizations have ways of accommodating employees who may be unwell.
Yeah.
Yes, because you cannot particularly say someone is going to be unwell for 14 days. Somebody could be unwell for a prolonged period.
Yeah.
But now you have to take into account the needs of the organization vis-a-vis the needs of an individual. So if you can have an arrangement of accommodating such an individual, it's well and good. But the law does not force an employee to keep an employer. I mean, an employer to keep an employee who perhaps may be sick beyond a year or so. Yeah. So it's essentially on compassion.
Yeah.
Yes.
Yeah. Oh, okay.
Yeah.
Wow. Yeah, because when it comes to medical issues and medical cover, who is supposed to foot even the bills at some point, is it also captured in law?
Medical cover, we have the NHIF, that is statutory.
Yeah.
But beyond that, any other cover that an employer chooses to give would be on their own evolution. So if it's captured in the employment contract that this cover is available for this category of employees, and then now someone falls sick and that is not provided, then they have a right to claim. But where it is not provided in your contract of service, then you can only rely on the statutory NHIF. Yeah.
And what is gratuity payment, and is every employee eligible to that?
Gratuity is essentially a gift. Yes, it's a gift that an employer would consider giving their employees periodically. It can be monthly, can be at the end of their employment, because people normally confuse it with service pay. They are all nearly similar. The difference is that service pay is paid at the end of employment. Yes, but gratuity can be paid at any given time. Yes, so the law does not essentially mandate an employer to make those payments, especially where an employer is remitting NHIF and NSSF. So if an employer is remitting NHIF, deducting and remitting NHIF and NSSF, then you have no right to claim service pay. Yes. Yes.
Wow.
All right. Wow.
Okay.
So it's good you are teaching us these things, because at times, I know my rights, but maybe kumbe wewe ndiye you don't know your rights. Yeah, and in studio this morning we are hosting Oscar Onyango, an advocate of the High Court. And today on Law Logs, being a Monday, we are looking at the labor laws in the country, and especially we are looking at the employment laws governing relationships between an employer and also an employee. We are waiting also for your questions. I know you could be having so many questions, including those of us who are in studio on set. White man, you can bring in those questions. Don't be afraid. You won't be victimized. We will keep your name anonymous. We have said your name, but don't be afraid. Ask those questions. 0708 222 323. That is the WhatsApp number, and also you can get us across all our social media platforms. That is Hope TV Kenya, right? Do we take a break and then we come back?
Let's take a short break, sip some water, and then when we get back, we'll be looking at your questions and also, looking at other things like paternity leave, maternity leave, which I think is also important. So don't go far.
We know you have great taste for music. And we do too.
I know who God says I am, what He says I am, where He says I'm at.
Enjoy all-time Christian hits every Tuesday from 12 p.m.
This is amazing grace. This is unfailing love.
on Hope Junction.
I've actually been trying to find a balance. It's been really tough and hectic, but everyone says once you get a hang of it, becomes better, and I don't know, but I'm hoping to find a balance soon because it's really been hectic. But you've been in the job industry for a long time, so I think you would know better. Sindio?
Huh? What time is it? I need to catch up on Leadership Forum. Did they have a radio here? Never mind. I brought my own.
No way. You can't be serious. Wait, why do you have a radio and you can just catch up with the shows on Hope FM podcast?
Really? Even with the what?
I mean, you can find them on whatever platform, name it. AfriPods, Google Podcasts, Apple Podcasts, Spotify, you name it.
But I'm not subscribed on any of them.
So no worries. You can just check out the latest episodes on hopemediakenya.org.
You can now listen to select Hope FM programs on your favorite podcast streaming platform or directly on our website, www.hopemediakenya.org. Listen and live.
Welcome back. We are having a great conversation that is also giving us lots of information with regards to the labor laws and, the Employment Act, what we need to know, because I mean, a very huge percentage of Kenyans, of people in the world are employed. But how well do you know your rights? And we have a lot of questions. I mean, there's just a lot. But I also want to touch on people with disabilities, because I think this is a section that maybe people don't really talk about it much, but I would love to know, are there, special laws when it comes to people who have disabilities?
Well, the primary law is the Constitution. Again, I will come to, when it comes to labor law, I'll come to Article 41 on fair labor practices. One of them being that an employee should not be discriminated. And then the Employment Act under Section 5 as protected grounds, on which provides that employees should not be discriminated on those grounds. One of them would be race, disability, sex, marital status, and ethnicity, and all those kind of common grounds where people would be discriminated. So when it comes to disability, I think over time employers have become more compassionate to disabled people, and you'll find that in organizations they've even made strands where people with disability would maneuver easily in the building and all that. Yeah, so that you do not terminate an employee because you would not be able to access the office that if they are able to work. Yeah, so persons with disabilities are protected. But again, it's not a blanket protection whereby now someone who is unable to execute their job are still kept in employment. There are special jobs that you would ordinarily not expect someone who is disabled to perform. For instance, in the armed forces or
Yeah.
in the police, you may not expect someone who is disabled to. Of course, there's some type of disability where they're not able to move, for instance, maybe to still work in that environment. So it's a balance. Yes, but ordinarily there is major protection for persons living with disabilities.
Yeah.
Yes.
Just a follow up, maybe, on, when you look at even how institutions are made, it's not every institution that puts into consideration that, what if someone actually gets a disability when they're working here, or can we have someone with disability in terms of even putting ramps instead of stairs, or stairs and also putting a ramp. So maybe in the case whereby someone has gotten disabled when they are working and they now have to use a wheelchair, is it going to be the responsibility of the employer to make sure that they're creating an environment that is going to be suitable for this person, or should that actually have been considered way before? What
Absolutely, those ones might arise, but again, you see, you look at our environment as a country.
Yeah.
Not all employers would be in a position to have buildings that have those kind of structures. Yeah, but you are required to make the environment suitable for every employee.
Okay.
So if somebody becomes disabled in the process, in the course of their employment, then you have to make some adjustment to allow a situation where they are able to perform. Yeah, so that you don't use that as a grant for now terminating them. That now we are not going to adjust. You are the one to be released. Then that one would be in conflict with the law. Yes.
Yeah.
Okay.
Yeah, and then there's something that I usually hear: out of court settlement. So you find this employee and the employer. So instead of pursuing this whole process, going through the legal process, the courts and everything, they decide, why not do it out of court, and they agree. And maybe even they reach an agreement and everything. But we are here for the sake of the employee. So even as, first of all, is it advisable? Number two, even as they are pursuing that route, what are the main things they should look out for, so that even as they are coming out of it, it will be a win-win situation. They will not be infringed, and also they will come out, should I say, victorious to some extent.
Well, today courts and majorly even advocates would encourage what we call ADR, alternative dispute resolution.
Yes.
So that don't have to take every conflict to court. Yeah, but on out-of-court settlement, I want to believe that's a matter that has found itself in court, and now you're trying to find a way to solve it without involving the court. Yeah, so the court would encourage that. Ordinarily, you can file a matter, but at some point, the employer feels that we do not need to go all through all this. We've had a relationship. We can always solve this amongst us. So what happens? Most lawyers would want to settle matters after they're filed, because that way, then the amount becomes elevated. Yes, as a practitioner, I would want to resolve a matter out of court after I've already filed it.
Okay.
Yeah, but nothing stops employees and employers from pursuing an out-of-court settlement. It's always the best. It saves you time. It also saves relationship, as well as the expense of having to file a case in court, paying an advocate to handle it, all that. Yeah, so it's an easy way out of a conflict. Yeah.
Okay.
Good. And there's something we had touched on about paternity leave, Kina Gigi. Were you given a... Okay, we'll ask you later.
Yes, I was given.
Rice. But anyway,
We had to announce. It's okay.
Yeah. So the paternity leave, I think sometimes it's a debate for other institutions, some organizations. What should one do if you're denied the paternity leave, and how important is it?
Well, any leave is important. If it's statutory, it's an important leave.
Yeah.
So paternity leave, just like maternity leave, is critical. So that one would put an employer at a very difficult position because you have a right to that particular leave. So if you are denied, you have a right to go to court and seek redress on that. But sometimes you are still in employment, but you've been denied that, so it becomes a bit difficult. So those are some of the challenges where employers should now work on policies. Policies on how to go for these particular leaves and all that, at what time and all that. But you have a right, absolute right, to proceed for paternity leave. Yes.
All right. Keep those questions coming, receiving them on Hope TV Kenya across our social media platforms and also on WhatsApp 0708 222 323. Straight to those questions. What should an employee do if the company fails to pay their dues and benefits when the employer goes bankrupt or closes due to financial constraints?
Well, we've had such situations. A company can go under for reasons not of their own, maybe of their own, or maybe they're not directly caused by themselves. So in that situations, there are processes that can be they can resort to. We have an administration process where they themselves they initiate, so that you are categorized as creditors. So we have secured creditors and unsecured creditors. So employees would also be considered under the category of unsecured creditors, so that when the company is discharging its obligations to creditors, then you are categorized under the same. Because ordinarily you would not force an employer who has no money in that circumstance. If they are filing for insolvency, if they are going insolvent, then you would not be able to glean that money from them, except with the help of the court.
Then someone here says, what should I do as an employee if my employer denies me that I think it's an opportunity for them to combine their leave days with maternity days, maternity leave. Then they go ahead and say, is it possible to readjust a law, like giving women employee 90 working days, not 90 days, including holidays and weekends?
Well, we are progressing as a country. That may not be where we are today, but we'll get to that place. There's no law requiring an employer to combine the two. Yes. But out of compassion, or out of their desire to support employees, employers may consider. Yes.
Yeah, and even on, I think it's just that same line of maternity leave. Could there be anything, like any law basically, that helps to consider women who are pregnant, like basically giving them, flexible working hours or something like that? Or is that even lawful or not?
Well, such things are workable. Actually, in other jurisdictions, they are, like in the UK around 2021, they were toying with the idea of even protecting women who are now facing that stage of called the stage of going to your 50s and all that, and the challenges that comes with that stage.
Menopause.
So they were considering providing additional protection because you'd not expect female employees to offer or work, give an output that is commensurate to that of male employees who are not facing any of these challenges. So I agree with you that we need to work on those so that we give accommodation to female employees, considering the special challenges that they may undergo under those situations.
There's something that you mentioned at the beginning of the conversation, and it was about timelines in terms of lodging complaints or cases in court. And we were citing the case that that you were handling, that there are time frames for the same. So how can an employee be able to get to know all about this? Because at times I think, should I say ignorance, which cannot again be applied in court. How do we come to know about these timelines?
There's something called limitation of actions. So, under for a claim of unfair termination,
Yeah.
ordinarily you are required to lodge it within 3 years
Mhm.
from when it occurs.
Yes.
So beyond that,
That is unfair termination. Yes. Yes.
So beyond that, if you're going to bring that claim to court, it would be stale.
Okay.
So, for example, with the matter that I was handling,
Yeah.
I think the lady must have been terminated around 2020,
Mm-hmm.
around that period. So by the time we were going to court last year, she was remaining with around 21 days before the lapse of her claim.
Yeah.
Yes. So you need to work within that period to lodge your claim in court.
Yeah.
Yeah. And I think when I think about this, I'm just imagining like we have so many people who just don't know their rights
Yeah.
when it comes to employees. Like for me, I'm getting to learn about these things right now. Most of them, I'm like, oh, okay, I'm getting to learn so much. I would love you to tell us how can employees actually learn about their rights, and while you're at it, also talk about the importance of actually going through the contract, because most people
Yeah. Very excited.
they just skim through. They don't even
Uh,
bother to analyze one by one. And from what I'm hearing is that especially you can find that kitu ambacho unajaribu kusuu watu, it was in the contract. It's just that you did not even go through it. You did not even bother to make those negotiations and inquire and make all these inquiries. What's the importance of making sure that someone really goes through their contracts, and also how can they educate themselves on the laws and on the rights that they have as employees?
it's important that an employee takes time to go through the contract. But essentially, employment contracts are standard form contracts. It's quite unfair on employees because you have little input
Yeah.
in the contract.
Yeah.
At that time, maybe you are so desperate for a job, you just want to sign that document.
Yeah.
But it's important that you take time
Yeah.
and know what is in the contract. For instance, I've handled situations where you have an arbitration clause in an employment contract. So an employer just handles things the way they want because they know at the end of it, you can't go to court because you're tied down to the arbitration clause. But courts have assisted employees who may not have an understanding of what an arbitration clause is. Because essentially it says that before you go to court, then you have to consider arbitration.
Yeah.
So you cannot rush to court in the first instance.
Yeah.
So you'll find an employee going to court only for the other side to file what we call a PU and say a preliminary objection and say, see, not considered.
Arbitration. Yeah. Yeah.
File an application to challenge that and say it's premature. Not considered this particular clause.
Yeah.
Yeah, so those are considerations that an employee has to take.
Yeah.
Go through your contract, understand what the terms are all about before you can sign.
Yeah.
But majorly there's a lot of protection for employees,
Yeah.
such that even with such unfair terms, the court would still come around various sections that the court can employ
Yeah.
in protecting employees who find themselves in those situations.
Yeah.
Now, arbitration is also quite expensive. For an employee who has just lost a job, that would not be a priority.
Yeah. Yeah.
If you were to apply that particular clause in the strict sense,
Yeah.
then you'd be saying that employees would not be bringing claims to court.
Mm.
So court has to balance and provide protection for employees in that regard.
Yeah.
Access to justice.
Yeah. And talking of access to justice, we were mentioning about the employment and labor relations court, and you said it plays a critical role in enhancing good relationships between employers and employees. And actually, they are there to serve the interests as well of the employees. Rarely do, or rather, we think that they are there to look at the other side, but you are encouraging Kenyans to seek justice in the judicial system.
Yes, actually, the court is one of those categorized as specialized court.
Yeah.
We have two specialized courts. We have the land and environment, then now the employment and labor relations court.
Yeah.
So the labor relations, employment and labor relations court is essentially to protect employees.
Yeah.
As it was found that a number of matters were employees had no avenue. So when this Constitution of Kenya 2010 was coming into play, it is one of the courts that were established under that.
Okay.
Yes.
All right.
So ordinarily, the claims that go to the employment and labor relations courts are those that where your salary, for instance, is above 80,000. So you have a salary of 80,000 and you have a dispute with your employer, you've been terminated, then the right forum would be the employment and labor relations court. So if your salary is below that, below 80,
Yes.
then you take it to the chief magistrate court.
Okay.
So the challenge you'll have if you take it there, it might be referred back, and you'll be wasting time.
Yeah.
So it's important that you start from there, then you go to.
Yeah.
But if your salary is above 80, just go to the employment court directly and lodge a claim there.
Okay.
Yeah, time is far much spent, but I think there's one thing that we can't finish the interview without asking about the annual leave days. At what point is one eligible, and what's the minimum, number of days that one should take?
You are eligible for annual leave days, which is 21 days, after you've worked consecutively for 12 months.
Okay.
After you've done 12 months consecutively, then now you earn the right to annual leave.
Yeah. And someone is asking, why do our nurses and other civil servants keep striking because of salary delays? Who sues the government?
Well, every individual has a right to sue the government. Yes, as long as you're a citizen of the country, if you have a challenge with a particular action that the government has taken, you have a right to sue. But you cannot go and sue on behalf of the nurses if you're not, for instance, unless it is a matter of public interest. For instance, that now it touches on the right to access to health care. Then, as a citizen, you'd proceed to court and seek interpretation of a particular law or protection of whichever kind.
All right. Advocate Oscar, thank you so much for finding time this morning to come and enlighten us on this vast and very important topic of labor laws and also matters to do with Employment Act. We can't allow you to go without giving us a parting shot and also how we can be able to maybe interact with you.
Yes, what I would say is that our duty, essentially, as advocates, is to help members of the public by creating awareness, such as this. I also do create awareness through my writings. I do articles, employment and labor law on Business Daily. I used to do on Standard, but I've stopped. So currently I do them on Business Daily. So we create awareness, and besides that, we also help members of the public to access justice. Yes. So the easiest way to find me, I have a law firm. We are partnering with my colleague, Mr. Brian Kiprono. Our law firm is Oscar and Associate Advocates. We are located in Hurlingham at Silverpool Office Suites.
Right.
So people can come through in case they need kutetewa. That's
and
good.
Our firm is basically, we specialize in employment and labor.
Wow.
Mostly.
That's good. That's good to know. Oscar and Associates.
Oscar and Associate Advocates.
Advocates, okay.
Yes.
Yes.
So you refuse to become a lawyer? Associate, sir. Your associate ni Gigi hapa na white man.
I can still go back to school,
Anyway, thank you so very much. We hope that you are now enlightened and that even as you're doing your day-to-day activities as an employee, that you will be able to know that, yes, I was able to be taught this, I was reminded this, and so I should do this. And also as an employer, this was also to remind you, just in case you forgot, that yes, even the employees, they do have their rights, and it is important for each and every one of us to know our lanes so that we avoid conflict. So thank you so very much, Oster Onyango, an advocate of the High Court, for coming through and enlightening us on today's topic. Right?
Yes, we've
And
come
call it
to
a day.
the end. Yes, we've come to the end of the show. Thank you so much for tuning in today from 7 all the way to now. We just have about 3 minutes to the top of the hour. That's 9 a.m. Asanteni sana. Tuonane kesho on one day at a time. My name is Beatrice Watare.
My name is Gichuru from us. Bye-bye for now.
Kuna njaa, niko na usingizi. For the first time I'm feeling sleepy.